very responsible actors in this space. But it's a fact that even if you're not ever signed up to Xmail or any of Xmail's services, any Ymail services, Ymail and all of its services are going to analyze your information. And that's very, very important. I'm on record predicting the following thing. Take the case of a 35-year-old healthy woman who is using a social network, and someone with her same last name is, not she, but someone with her same last name to whom she's connected on the social network is a member of a cancer survivors group on Facebook or on another social network, just another social network, okay? And also, through her browser, this 35-year-old woman is visiting cancer center treatment websites. And she receives an email, does not create the email, she receives an email about breast cancer. Right? My prediction is that healthcare insurance executives want that information and are going to try very hard to get it. And I think they're going to get it, okay? Unless we do something about it, okay? So this is very real. This is not just about behavioral ad targeting. It's very real. It's not happening today. There are, thankfully, good protections for healthcare information today. I don't think they're adequate, but this is coming, in my opinion. Twitter conversations are public and searchable. This is sort of half in, half out. The point here is that a lot of the places where we publish information about ourselves, the rules change about what is public, what is accessible, what's private, what's public, what will be shared, sometimes every few months. So what we expect to be true early may turn out to be false later with respect to our privacy settings. Very famously, one of the biggest social networks in the world just did a deal with a data mining company last year because they're hurting for revenue. One of the biggest social networks in the world did a deal with a data mining company last year because they're hurting for revenue. They need the revenue. And now this data mining company, which has been slammed many times in the public for being very, very aggressive with its data mining practices and data sales practices, has access to a data set, a social network data set, that is deep and rich beyond anything they had before, right? And this is part of the life cycle of business, right? There will be some networks that win, there will be some that lose, and the ones that lose may need ARPU. They may need more average revenue per user. They may need more revenue, and they may be willing to do deals at the end because the management has changed, the board of directors has changed, and the objectives have changed around revenue generation. Also, of course, we all know that personal information is very easy to find. I would hazard to say that none of you has ever, is my guess, none of you has ever willingly put your information on one of the probably 250 databases on which my team can find it within a few seconds if you give us a chance. But it's there. And then, there's kind of more innocuous stuff like your marathon results, which we can be proud of or not, or campaign contribution information, which may reveal our home address or not. The idea is that we're not opting in anymore. It's just not the right framework for the discussion. Assumption 3. If we change the rules, will the internet break? There's some concern that the laws that we have on the books today, and I'm generally inclined towards market-based solutions, but I also am worried that the laws that we have today are from the Mesozoic era of the internet. The laws that govern the internet today were basically passed in the mid-'90s, which really is like a billion years ago in terms of what we knew about the internet and the strength of the internet today. They may be adequate to the task, or they may not be, but they've yielded some very unintended consequences. We all know that the Digital Millennium Copyright Act of 1998 protects copyright, and it does so reasonably well, so much so that NBC can send one letter to YouTube and force it with one letter to remove 50,000 videos. But if your kid is caught on this digital camera phone, filmed at a party, and that video is posted on YouTube, legally he or she is out of luck. Why? Because the law that regulates privacy, the Communications Decency Act, basically, of 1996, is a lot more circumspect and a lot less toothy when it comes to protecting privacy. There's a fear, and it's a reasonable fear. There's a fear that if we change the law very conscientious, very smart people. There's a fear that if we change the law, that we will freeze the internet, that we will chill the internet, we'll destroy it or turn it into an iceberg. And very, very conscientious people with whom I agree on 99.8% of things say this in the public very routinely. I think there are examples in the world that we can use as legally minded analogizers and disanalogizers as we are to either emulate or not to emulate. The Digital Millennium Copyright Act has a notice and takedown provision that has some promise if we want to protect privacy. Also, the other countries around the world, Europe, Latin America notably, do protect privacy more than we do here in the States, and the internet is not dead there. There are a lot of photos here in the internet in the U.S. There are a lot of videos protected by copyright. And in Europe and in Latin America, there's a lot of internet too. There's a lot of stuff. There are a lot of Craigslist types of things. There are a lot of Facebook types of things. So I don't know that it's true that we would kill the internet if we nipped and tucked here a little bit. If you listen to some of the very smart and very thoughtful people who are adamant that there be no change at all in the law, if we take their opinion, if you listen to them, they'd have us believe that any change in the current law will result automatically in like Stalinism. I mean, it's really strong. That any change in the current law will result in a total freezing of the internet. I've been on panels with very, very smart people of this point of view. We've debated. We've had civil dialogue on the internet. It's a very important discussion. We don't want to overreach, but I don't think that we're 2 steps from Stalinism. I think we're 100 steps from Stalinism, and taking 1 or 2 steps to restore the balance between privacy and other concerns is something that we should examine. This is my last one. I love this slide. It's so patriotic. It's intended to mean we are Americans and we can solve anything. I love that. And that's what this slide is intended to show. That these are tough problems, but I actually think we can do it. And in answer to a question that was posed of the panel, I don't think this is just an issue of rights or of economy or of commerce. I think that we're going to solve this the way we always do, which is incrementally. And we will solve this through market-based solutions like mine or like Microsoft's or others. And we will also find a way through litigation, legislation, and regulation to nip and tuck here and there to make our offerings more supportable and attractive to consumers. Consumers are worried, and they're feeling very, very helpless. And they are voting with their feet, but they're also getting more and more entrenched in data sharing that they did not sign up for. So the passion is there, and when Americans feel that kind of passion, they will do something about it. And I want us to do the right thing and shape it the right way. Well, thank you very, very much. That's all I got to say. Thank you. Am I taking questions? Oh, hello. Questions are welcome if you have them. But if you want to carry on with your lunch, I understand that. Yes, sir.
Michael, we couldn't be closer to Congress. So what would be your model law? What would you ask?
Yeah, I get this one a lot. What would be my model law? I've been working on it. I've been working on a specific proposal, and I'm not there yet. So here's what I think. I think that there is sufficient similarity between copyright concern and privacy concern, and in some ways between trademark concern and privacy concern, that we have a lot to learn from the provisions of copyright and trademark when we want to protect privacy. There are weaknesses of that similarity. So copyright may be more identifiable than a libel, for example, although it's not clear that that's true. Fair use muddles everything. But it's directionally helpful. I think that what I know of Brazil's jurisprudence on this topic, in which ISPs can have intermediate action responsibility, not liability, to take down content. Right now, under the law, if you are defamed, I mean actually defamed on a website, not by the website owner, but by a third party, anonymously, then you can sue the third party, the anonymous third party, if you can find them. And if you win, you might get damages, but the content still stays on the website. And there's no way to get it down under the law today. That's weird. It's weird that